I think you're all dismissing their argument as being stupid or irrational or not sounding like this is something a lawyer would ever say. And I think that dismissal is pardon the pun, unwarranted. But I know that when Nick was going through his motion, to the extent he was able to go through it, he made a point that when you get a specific warrant to go after a specific thing, and then you find evidence of another crime, you are duty bound before you seize evidence of a different crime to actually get a warrant to take and say, hey, look, we're only allowed to take this stuff, even if it's in plain view. The plain view doesn't open you up to say, now that we have a specific warrant for crimes, alleged crimes A, B, C, then now we can start pulling up other stuff that might be evidence of issues D, E, and F.
If we're going into a place and we're looking for item A, right? But in this case, it's cocaine. Then we go in, and so there are a couple of rules that you can't overcome. Like we used to call it the elephant in a suitcase rule. If I'm looking for an elephant, I can't look in your suitcase, right? But in this case, especially when you're talking about drugs, you're talking about something that's very small. So you don't have this elephant in a suitcase issue. The plain view exception is if a cop is legally in a particular place, besides the warrant, legally in a place and sees criminal activity, you see cocaine, you see whatever, you can search it. So in this particular case, when they went into Nick's house with the warrant, their warrant gave them the legal right to be in that place. Now, when they're in that place, the cocaine is illegal. So now they seize the cocaine. Now, if you see something else that's illegal in there, you can seize it because the Fourth Amendment guarantees you can seize stuff. The government can seize stuff based on probable cause.
I'm not asking you. That's the plain view that you're saying that you don't need to get another. You don't. I don't know the law. I don't know. I'm not telling you I know the law. I'm telling you. I think you might need another warrant on that.
I'm just trying to explain to you how the law is in this particular instance, right? In this particular case, the plain view doctrine has to deal with something that is obviously illegal. And so if Nick's, let's say for instance, if Nick's guns were somewhere where it wasn't wasn't obvious, it was locked up, it was somewhere where the cops had to go this extra mile to go find them, then yes, you can make the argument. But if they're in plain view in the search area and they say, well, you got coquina here, well, you got guns. You can't have guns with coquina. The guns now are illegal because you have cocaine there.
So my understanding of probable cause is probable cause gives you a license to get to make sure that you're safe from being harmed by this potential criminal, and then to go get a warrant. Probable cause itself is not a warrant. That's my point. And that's why, I mean, it sounds as if you're treating the probable cause of this additional crime as in and of itself a warrant. And I don't know. I don't know. I haven't researched the law. I don't know. It sounds as if so once you have probable cause, why do you have any warrant? You have probable cause. So
you guys have been talking. I've been doing some case law research in the background. So this case seems like it might be on point. Horton versus California, U.S. Supreme Court, 1990. Question: does the Fourth Amendment prohibit warrantless seizure of evidence in plain sight if the discovery of such evidence was not inadvertent? No. Writing for a 7-2 majority held the seizure of evidence in plain view does not constitute invasion of privacy that the Fourth Amendment is meant to prohibit. Once an officer has a warrant to search a house, that officer may seize any obviously incriminating evidence the officer finds in plain view. Yeah, so I think this case seems to suggest against.
No, it doesn't suggest.
It's black letter law.
It blows up my argument. It blows up my argument completely on this particular element. I agree with you 100%. That being the Horton seems to be right on point. It blows up my argument that I was saying they need to get a new warrant. Supreme Court says, no, Joe, they don't. So you're right. And my thoughts on this, which this is how I understood Nick and Barnes to be arguing. I might have misinterpreted their argument, but that's how I understood their argument. I'm glad you actually helped bring that case to light. And you're right, and I was wrong on this.
Well, this is a legal question, which I think on civil, I immediately said to him, okay, there's the answer on the law. You're right, which means that if in fact this warrant is lawful, but with respect to the guns that they seized, which are not listed anywhere in the warrant, based on Horton v. California, which was decided by the Supreme Court, I think you probably can say that, hey, they're probably going to be able to, the state will probably be able to keep those guns as evidence and they will not be suppressed. That's my legal assessment based on this case, which Kurt brought up there, did a little quick digging and found that out and pulled it up there on stream.
So those two videos that I just showed you were from yesterday, and they could not have come out at a better time because today, Friday, August 30th, the state has responded to Rekieta's motion to dismiss. I am not going to read this to you. It is 10 pages. If you're in my Discord, you've probably already read it. So I'm posting it on screen. Pause and read it if you need to. Basically, they say the exact same thing that Nate and Uncivil were trying to get through and eventually did get through to Good Logic. Of course, this is the state's response. We will hear back from Nick and his attorney by next Friday, and then the judge will ultimately make her decision, and then we will know who was actually right.